Good morning. This is Professor Donald Gifford, the Jacob A. France Professor of Torts at the University of Maryland Francis King Carey School of Law, here to discuss Borel versus Fibreboard Paper Products Corporation. Welcome, Professor Gifford.
Thank you so much, Rick. As Rick said, I'm here today to discuss the case of Borel versus Fibreboard Paper Products that was tried in the Federal District Court in Beaumont, Texas in 1971. I suspect you've seen advertisements on TV from attorneys that are soliciting victims of asbestosis, mesothelioma, and other diseases caused by asbestos exposure. Borel was the first successful lawsuit against manufacturers of asbestos products. Clarence Borel began working in the insulation business in 1936, and he continued in that field for 33 years. And in his deposition, that is his oral testimony prior to trial, Clarence talked about how at the end of the day, his clothes would be literally covered with asbestos dust, and that he would blow handfuls of asbestos dust out of his nostrils. Now, he testified that he knew that the dust was, as he put it, bad for him, but that he also heard from fellow workers that it dissolved when it hit his lungs. He also said that he never realized that exposure to asbestos dust could cause serious and fatal illnesses, such as asbestosis and mesothelioma.
Let's pause briefly. What is asbestos?
I'm going to get there.
Oh, okay, go ahead.
If you want, I can talk about it now, but
No, carry on.
Okay, thanks so much. Okay, where were we? In 1964, Borel was told by a doctor that his lungs were cloudy, and it probably related to his work in the insulation field. 5 years later, 1969, he had a lung biopsy performed, and he was diagnosed with asbestosis. The very next year, he was diagnosed with mesothelioma, an even more severe and fatal illness. So Clarence Borel sued 11 manufacturers of the asbestos insulation products that he had used throughout his career. 4 of those defendants settled with him prior to trial. The next year, Clarence Borel died, and his widow was substituted as the plaintiff, that is the claimant, under the Texas wrongful death statute, which enabled her to recover damages for the loss of her husband. In earlier decades, asbestos was regarded as a miracle fiber. It was a mineral, but it was fireproof, and it could be woven. So for decades, it had been used in asbestos roofing, asbestos insulation, asbestos gaskets, sometimes asbestos clothing. And all of these products were regarded as miraculous because they prevented the spread of fires and saved thousands of lives. But the evidence presented at Borel's trial proved that the manufacturers had been aware that asbestos caused asbestosis for more than 50 years, and that they had failed to warn the workers and the others who came into contact with their products. In his lawsuit, Borel and his lawyers alleged that the manufacturers were liable under both the traditional claim of negligence and also under a relatively new cause of action, strict products liability. After the jury awarded damages to Borel's estate, his wife, the manufacturers appealed to the United States Court of Appeals for the Fifth Circuit. There, The case was assigned to Judge John Minor Wisdom, a highly respected and influential judge who had become famous because of his opinions in civil rights cases. The overarching important conclusion that emerged from Judge Wisdom's opinions in Borel was that for the first time, strict products liability was applied to products causing occupational diseases and other latent diseases, that is, diseases that manifest themselves only after a period of time has passed since exposure to the product. The court held that the manufacturers had a duty to adequately warn the workers and the others exposed to their products of the dangers that the asbestos insulation posed. From now on, manufacturers would be required to keep abreast of the scientific knowledge about the risks posed by their products. Because this was the first case applying strict products liability to products that caused latent diseases, Judge Wisdom's decision covered several other important issues. First, the court rejected the manufacturer's argument that their only duty was to warn the party that had directly purchased the asbestos products, that is here, the insulation contractors. The court held that the manufacturer could also be held liable for failure to warn those who, like Borel, ultimately used the product. Second, Judge Wisdom rejected the manufacturer's arguments that Borel's estate should not be able to recover because of Borel's own conduct under defenses usually referred to as contributory negligence and assumption of risk, even though a different phrase was used under Texas law. Judge Wisdom held that Borel's vague notion that the asbestos dust was bad for him did not shift responsibility to Borel to avoid the dust when the manufacturer knew or should have known exactly how dangerous the product was and failed to warn Borel. Finally, the court held that Borel had filed his lawsuit in a timely basis within the so-called statute of limitations, the period of time during which a lawsuit must be filed. For purposes of determining whether the filing of the claim was timely, the court borrowed what was known as the discovery rule from medical malpractice cases. The court held that the statute of limitations did not begin to run until the victim either discovered or in the exercise of reasonable care would have discovered the serious nature of his or her disease. Specifically, in this case, the court found that the statute of limitations did not begin to run until the time that Borel had his surgery for asbestosis. Following Borel, more than 700,000 victims of asbestos-related diseases filed claims against manufacturers, making asbestos litigation the most important new genre of cases in tort litigation during the past 50 years. All or virtually all asbestos manufacturers would end up in bankruptcy because of their inability to pay these claims. Asbestos cases are very different from the kinds of accidents that traditionally fueled American tort litigation. First, the harms inflicted by asbestos manufacturers were diseases, not broken bones. Second, asbestos disease usually does not manifest itself until 15 or 25 or even 30 or 40 years after product exposure. This is unlike auto accidents, railroad accidents, and the other staples of earlier generations of tort law, where the harm, the broken bones, occurred instantly. Third, in an auto accident or in similar torts, it is generally known who the party was that caused the victim's harm. But with asbestos litigation, the victims often had been exposed to products from any number of manufacturers. In the case of Borel, 11 different manufacturers. So Clarence Borel's claims clearly pose new challenges to traditional tort law. Thus, asbestos claims changed the law in ways that paved the way for future generations of tort litigation against manufacturers of products such as cigarettes, lead pigment, and opioids, as well as against those who pollute the environment in ways that lead to cancer and to other latent diseases. Thank you very much.
Thank you very much.